All right, good morning, everybody. Welcome. Thanks for logging in to listen to me talk about mediation. If anyone has any issues with the audio, or if you have any questions along the way, you can submit a question, and I will try to answer it either during the presentation or right when we're wrapping up. As you know, my name's Howard Ehrenberg. I'm a partner at SulmeyerKupetz, and I've been practicing in the area of bankruptcy and insolvency for 30 years, unbelievably. For the last 21 years, I've been on the panel of bankruptcy trustees here in the Central District of California. And over the years, I've seen a gradual but steady increase in the use of mediation to resolve disputes, to the point where it's been years since I've had a matter where I was the trustee that actually had to go all the way to trial. About a year ago, I thought, well, I could probably do this. So I decided to enroll in the LA County Bar's basic mediation training, which I completed in January, and I'm now on the panel of mediators in the bankruptcy court. So I thought I would share with you a little bit about what I learned at the mediation training and how I believe that in the context of bankruptcy, the use of mediation is exceptionally effective. So the structure of a mediation has many steps to it, and I know that recently people don't like to have the plenary session, the introductory session with the mediator and the parties, that everybody seems to think they know how this is going to work and that that's just sort of an unnecessary use of time. I'm beginning to believe actually that even though that takes a few minutes, given that mediations generally take several hours, I think it's worthwhile to have that session for a few minutes for a number of reasons, especially in cases where interpersonal conflict is part of the problem. Assuming that the parties are adult enough to sit in the same room together, I believe that it's useful to have the parties face each other and state their issues so that the other side can really hear firsthand and not be filtered through lawyers and the mediator. And so when I ask the parties to briefly discuss their case, what I'm doing is I'm listening for the issues that are really underlying the dispute. And by doing that, sometimes we can reach some areas of common ground rather quickly and eliminate some of the problems that could last all day, but by having the parties together for a few minutes, we can short-circuit the entire process. And then by taking the issues that remain, we then create an agenda. And I think that having some structure to the day is helpful so that people know what to expect. I'm able to tell them how I plan to conduct the mediation, whether it's keeping the parties in the room together or separating them into separate caucuses. But I think that setting an agenda serves two purposes. It helps the parties to specifically define the issues that will need to be talked about and resolved, and it provides a roadmap for the rest of the mediation session. I found that many sessions will continue for an inordinate amount of time with no apparent progress if the mediator does not work to establish the items for discussion. It's a little bit too free form, and while certainly you want people to feel comfortable and to express themselves, trying to get them focused is ultimately what has to happen in order to be successful. The next step is then individual discussions, and I will take the parties into separate rooms and see if there's something that is not being said in the group session that I need to understand. And then I will generally use sort of shuttle diplomacy to go back and forth. Occasionally we will reach an impasse, at which point the idea of brainstorming comes into play. And the idea of brainstorming is to let the parties just throw out ideas and say that no idea is too crazy or too out there to not be considered. And so many good ideas to solve problems are lost before they're even offered due to people's need to be focused just on, let's say, the money. But brainstorming is an easy and effective way to generate ideas, and the rules are simple. You say to the participants that we're going to set aside a brief amount of time where they can give any ideas that they like, and none will be accepted, none will be rejected rather, and all will be accepted. Generate as many ideas as possible, and then we will proceed to discuss them again in private. Hopefully, by the end of the day, of course, an agreement will have been reached, and everybody probably has a war or horror story about the parties leaving the mediation at 10 o'clock at night. Everybody's tired, nobody feels like writing, and everyone goes home with the best of intention to have the lawyers put it down in writing the following morning. And when they try to do that, they think of all kinds of issues that weren't discussed the night before, and you no longer have an agreement. So one of the key elements of a successful mediation is to put it in writing. Confidentiality is one of the hallmarks of mediation, and confidentiality exists in three different ways in the mediation process. The first is that under settlement rules, everything that's said in the mediation is confidential and can't be used by the parties in court, nor are they supposed to be used for discovery purposes. Now, it's obviously hard in reality if you learn something to then not be able to use it in the future, but you certainly can't put into a pleading something that was discussed in a plenary session in the mediation. The second is that a mediation is confidential as to the judge. A mediator cannot be called to testify at a subsequent hearing about what was said during a mediation. In certain mediation settings, the mediator may be asked to describe the level of cooperation of the parties, but that is not the same as disclosure of anything that was actually said in substance. And finally, the parties to the mediation need to know that whatever they say privately to the mediator will not be disclosed to the other side unless the party specifically permits the mediator to disclose it to the other side. So it's an opt-in rather than opt-out situation. It's also easier for the mediator to assume that whatever is being told shall not be repeated unless the party specifically says so, and then the mediator can make note of it so as to not make a mistake in the shuttle diplomacy part where the mediator's intent may be good to try to describe to the other side what's motivating the other side, but by reminding the mediator that nothing shall be disclosed unless it's specifically permitted, I believe that that helps the parties to open up and feel that they can be completely honest because they know that nothing will be repeated unless they give permission to do so. I learned that there's basically two different styles of mediation, and probably many of you have experienced both of them. The first one is facilitative mediation, where the mediator structures a process to assist the parties in reaching a mutually agreeable resolution. The mediator asks questions, validates and normalizes the parties' points of view, searches for interests underneath the positions taken by the parties, and assists the parties in finding and analyzing options for resolution. The facilitative mediator does not make recommendations to the parties, give his or her advice or opinion as to the outcome, or predict what a court would do. Rather, the mediator is in charge of the process, while the parties are in charge of the outcome. And in many areas where mediation is used, that's the primary way in which the mediator will act. However, in bankruptcy, we frequently use retired judges, and part of the reason why we do that is because we want a judge who's actually been involved in cases like this to tell us what he or she thinks. And so the other style of mediation is evaluative. Evaluative mediation is a process modeled on settlement conferences held by judges. An evaluative mediator assists the parties in reaching resolution by pointing out the weaknesses of their cases and predicting what a judge or jury would be likely to do. An evaluative mediator might make formal or informal recommendations to the parties as to the outcome of the issues. Evaluative mediators are concerned with the legal rights of the parties rather than their needs or interests, and evaluate based on legal concepts of fairness. Evaluative mediators meet most often in separate meetings with the parties and their attorneys practicing shuttle diplomacy. They help the parties and attorneys evaluate their legal position and the costs versus the benefits of pursuing a legal resolution rather than settling in mediation. The evaluative mediator structures the process and directly influences the outcome of the mediation. So the issue is, if you're not going to hire a retired judge or a current sitting judge to act as the mediator, there ought to be an agreement in advance, at least amongst the lawyers, as to how they would like the mediator to conduct the mediation. It should be known in advance whether they're seeking the mediator's opinion or whether they're looking for the mediator simply to facilitate the parties reaching their resolution. There are a number of strategies that a mediator can use in the conduct of it. And one that seems to be less in favor in the bankruptcy setting is more group sessions. And sometimes you can all think of situations where just putting the parties in a room where eventually they have to talk sometimes will speed up the process rather than have shuttle diplomacy. And especially in cases where the parties are not really personally antagonistic to each other, where things may devolve into an argument, I think that we should use more opportunity for group sessions and not have the parties separated. I believe that many disputes that are fairly basic from a business perspective could be resolved face-to-face with only limited need for private discussions, maybe where the parties and their lawyers step out for a minute or two and then come back into the group setting, as opposed to the mediator shuttling between two different rooms. Another issue, it's under the cell here, possible strategies, is realistic numbers. I think it's very important for everybody to realize, and I learned this in the training, that when the first party gives out their settlement figure, let's say the defendant in the action says, this is a terrible case and I'm not going to offer you more than $1,000. And the other side comes back and says, this is the most egregious action ever and I'm not settling for less than $1 million. So you now have $1 million against 1,000. That does not mean that the case ought to settle at 500,000. And it seems like there's been a tendency to believe that when the second party gives out their number, that you immediately know what the midpoint is and that that's where you're going to settle, and it's just a matter of time until you twist the arms of both parties to come up and come down, as the case may be. I think what's important is that before the parties give their opening offers, is that they talk seriously about what is realistically the likelihood of obtaining a number close to that demand at the end of the day. And if the parties can be more realistic, so that the defendant doesn't say, I'm only going to pay you $1,000, but rather says, okay, there are some weaknesses in my argument, and I'm willing to offer $10,000. And the other side says, I know I'm asking for $1 million, but most of that is speculative, and instead be persuaded that in their mind the case really should settle for between $50,000 and $100,000. Then at that point, if you can get them to make realistic offers, then the midpoint may be something that is more achievable, rather than have the parties be so far apart that the mediation is very unlikely to succeed unless one of the parties blinks first. And that's why I think that it's very important to speak to the parties about being realistic and not just bombastic. Creative alternative resolutions, not every case is just dollars and cents, and sometimes the issues of the parties, especially in business cases, in bankruptcy situations, relates to the future. And sometimes the parties should be offered alternatives, such as settle for a modest amount, but the company agrees to continue doing business with the other side. Not that the other side will make up the money over time by overcharging, but simply by the fact that they don't lose a customer may be more motivating to them than the issue of having to write a check in order to settle a preference or a fraudulent conveyance claim. So it's important to think about what else might be done that is not strictly a monetary exchange of dollars. There are many challenges in a mediation. The first is bankruptcy court approval. It's important to remember that the judge can independently decide whether or not this settlement makes sense, and creditors and other parties who were not part of the mediation may have a lot to say about the settlement. So it's important that the settlement be a real settlement and not something that is in some way intended to disguise some other arrangement, so that it can then be picked apart by creditors or the court, wondering why the parties are settling for what might appear to be a very nominal amount, which would raise the ire of creditors or other parties. Other challenges include interpersonal conflict. Now, if you've got a case where one family member is after another, or a divorce bankruptcy, or an employer and an employee, it is important to spend the time to try to get the parties to focus on the underlying legal issue and to try and set aside, for purposes of the mediation, their dislike or hatred of the other side. And that's what often takes the most amount of time. And it's also why I believe that group sessions are important, because you frequently find that really what a party just wants is to be able to get their feelings off their chest and to be listened to by the other side. And so by facilitating that opportunity, often the heatedness of the dispute can be lessened and make for more opportunity for a meaningful settlement. The other challenges are different negotiating styles. And I believe that we've all seen the different types of negotiation styles that the lawyers bring to the process. I will talk about those four styles in their order of aggression. The first being the most aggressive, which is competing styles, where the parties pursue their own goals regardless of the other person's concerns. They make the first move, they attempt to gain control of the mediation and maximize their chance of obtaining a desired outcome. They will prolong the discussion until the other person gives in to your approach. This is where you have a win-lose style, and it is very difficult to be successful in a mediation if both sides are approaching it from one side has to win and one side has to lose. The second most aggressive is called collaborating, where you determine where each party stands, you identify options available to meet both parties' needs, and the mediator suggests combining the ideas to the other person's ideas to make for a more workable solution. You express concern for the differences between you. You let the other person know that you want to resolve it that satisfies you. The idea here is a win-win, where I get something and you get something. Everybody walks away a little unhappy, which I think is often thought of as the definition of a successful mediation. The third least aggressive is compromising, where you point out to the other person that if you will both make a few concessions, that the conflict can be resolved quickly. The mediator needs to point out that if the disagreement is to be resolved, each side must make some sacrifices in order to achieve that goal. This is most likely to happen where the parties wish to preserve their relationship, and so by making a compromise, they can continue to be friendly or in a business setting to have a future business relationship. The least aggressive style of negotiating is accommodating, where one party comes in and basically offers to handle the problem in any way the other person wants. They go along with whatever the other person requests rather than get into the difficulties of direct confrontation. And sometimes this is what happens. A party says, I'm done, I just want to get this over with, make the best deal that you can for me, but at the end of the day I'm going to sign on to a compromise. And if so, I think it's important for the mediator to look out for the interests of the person who's accommodating to make sure that they don't get taken advantage of, but ultimately it is the party's mediation and they're the ones that get to decide how it should be approached. So the agreement. Now, the agreement is ultimately the success of the mediation, and it's important that the parties take the time at the mediation to put the agreement in writing. Do not let the parties leave before signing, and to the extent possible, try to make the agreement the full agreement. Sometimes the parties can bring a pre-written template of an agreement or ask the mediator to have a template of an agreement, so that what you're not signing off on is just a bullet point of the most salient points, but all of the issues that can derail a settlement if not agreed upon in advance. One of the things that I learned in the training is to make the agreement SMART, and S-M-A-R-T. The S is specific. You need to say who, what, when, where, and how the settlement will be effectuated. The M is measurable. How much, for how long, for how many. So obviously if you're talking about money, you know about how much and how long it will take to be paid or how many payments will be made, but it needs to be specific. The A is attainable. Will both parties be able to meet their agreed upon obligations? It doesn't make any sense to reach an agreement where one party is agreeing to pay a certain amount of money that they could never afford to meet, or to take certain actions that they don't have the ability to perform. So an agreement, even if the party expresses their desire, needs to be achievable. The R is realistic. Are the necessary resources available? Again, this is similar to attainable, but realistic is important, that the parties understand what they're agreeing to and that they actually can perform in the end. And then the T is time defined. By when will each party of the agreement be completed? In a simple exchange of money, we know what that is, but in some situations where there's going to be an ongoing relationship or a collection of, let's say, accounts over time, there needs to be some way of defining the end date so that the parties know that this is not open-ended and will actually be completed. So I think I've taken up just about my 30 minutes, and I'm happy to answer any questions that you might have. So far, I don't see any. So let's see. Oh, we got a question. At the outset of a mediation, do you ask the participants to sign off on rules and procedures for the mediation? The answer is yes, yes I do. And in fact, I try to send the parties a pre-mediation instruction sheet so that they are prepared and less time is spent explaining the rules. Clearly, everybody has to sign off on a confidentiality agreement, which I maintain, and I will usually ask the parties to provide me with a confidential mediation brief, trying to limit it to 5 pages, but I'm not going to stop reading like a district court might if it exceeds that, but try to get the parties' thoughts on paper so that when the mediation begins, it can be efficient in that the issues have already been outlined. Yeah, if you send me an email afterwards, I'll be happy to share the templates that I received. I don't think there's any copyright problems with those. They were provided to me for use, so I think there's no problem in that. Somebody wrote, who pays? Can you open that up? Who pays for the mediation? Well, sometimes nobody. The bankruptcy mediation panel, the mediators agree to do one free mediation per quarter, but otherwise it's generally split between the parties. And if anybody is interested in my services, I'll be happy to talk to you offline about it. I don't think I should be soliciting business on the webinar, but generally it is split between the parties. If there are multiple parties, it can be split multiple ways. I usually charge for the day or half day rather than by the hour, and a day would include the preparation time as well as 8 hours of mediation. And very few mediators will stop at 8 hours if progress is being made, and I think that's only right. All right, I think that's all the questions we've received. This has been fun. I hope you've learned something, and I appreciate the opportunity. Thanks very much. Bye-bye.